Hi, this is Seema Arora, and this is a podcast on sustainability, climate, business, economy, and tech. Today, I have a special guest. His name is Dr. Gregory Werden, and he is appearing on the show for the second time. We are going to continue our conversation on Google and the antitrust cases, and especially today, we are going to talk about the Epic Games versus Google case. Before I go into the details of the topic, I would like to introduce the guest again. Dr. Worden worked at the Antitrust Division of the US Department of Justice for over 40 years. He's prepared numerous guidelines and briefs for the department. He's the only Antitrust Division employee ever to get the Mary C. Lawton Lifetime Service Award. And after retiring from government service in 2019, he has written a book titled The Foundations of Antitrust Events, Ideas, and Doctrines, which I have thoroughly enjoyed reading. The last time in the podcast, I had bought myself a Kindle copy, and now I have a paperback edition. So I highly recommend it. And so glad to have you, Dr. Worden, in this show.
Thank you.
Yeah. So today we are going to talk about the Epic Games versus Google case, um, which has been in the news. This case was brought about uh, in 2020, and it questioned the whole idea of the economics of app revenue delivered via the Google Play Store. And it delves into the issues of Android and how it is going to be financed. And so let me give it to Dr. Worden to introduce what the case is about, and then we'll talk about the specific economic aspects that are under contention at the Antitrust Division and whether it makes sense or not. Take it
Thank
away.
you.
Yeah.
Uh, as pretty much everyone knows, Google orchestrates the Android mobile device ecosystem. Google spends a lot on Android development, but it doesn't charge to license Android.
Yeah.
It doesn't charge users, it doesn't charge device manufacturers, doesn't charge anyone. Nor is Google's investment funded by selling Android devices. Doesn't sell much hardware.
Mm-hmm.
Android is financed by taking a commission when a user of an Android app makes a payment to a developer. That payment could be to buy the app in the first place, but usually it's an in-app payment later.
Mm-hmm.
Epic Games is a video developer known for its game, in particular, Fortnite.
Correct.
And like many app developers, Epic Games operates on what's sometimes called the freemium model.
Mm-hmm.
You download the game without any charge, but you can make in-app purchases. And in fact, some of the people who play Fortnite spend a lot on in-app purchases. And Epic's not alone in using this model. I was very surprised to find in the course of this litigation that nearly all of the revenue that Google garners from its Play Store comes from in-app purchases. Not from app purchases, but from in-app purchases.
Okay.
And for most apps, a small fraction of the users make most of the in-app purchase. So from the beginning, Google and Apple charged around 30% commissions. They've come down a little bit. There's some negotiation. There are reductions for small app developers. It's a little bit complicated now. And Google was perfectly willing to negotiate with Epic Games. But
Right.
Epic Games was not willing to negotiate with Google. And instead, Epic Games hired lawyers to file an antitrust suit.
Yeah.
Now, what the suit is about is the mechanism that Google has put in place to make sure that it could collect its commission. And that mechanism is to require the app developers to use a payment service that Google created to process those in-app purchases.
Okay.
Now, Google doesn't really care who literally does the processing, but they care about the security.
Yes.
And they care about collecting the commission. But Epic made this about competition to be the processor, even though there really never was any competition. As far as we know, nobody wants to be in that business besides Google. So Epic, trying to be dramatic, I think, described the commission that Google collects as a tax. And in part, it is. And I think it is useful to go back to this quotation from a Supreme Court case in the 20s. Justice Oliver Wendell Holmes, one of the greats, said taxes are what we pay for civilized society. And his point is that nobody likes to pay taxes, but we got to do it. And this is just as true for the Android ecosystem as it is for the United States of America. There has to be a source of revenue to fund the system.
Yeah.
But nobody wants to be the source of revenue. It's the problem you constantly have.
Yeah.
Every user of an Android phone benefits from all the investment Google has made. But taxing the individual users is kind of problematic. I mean, how would you do it? Charge a monthly fee for owning an Android phone? Not
Yeah.
very practical. So the logical source of revenue is to tax transactions.
Yeah.
And what are the transactions? They're the in-app purchases. So that's what Google is taxing. And back when they started out, there were no such thing as in-app purchases, and what they taxed was app purchases.
Mm-hmm.
But developers figured out, we can escape the tax on app purchases by not charging for the app. And we'll charge for something else. So Google said, oh, okay, that's fine. But I'm going to tax that thing too.
Yeah.
So you can't escape the tax.
So,
And
yeah.
and so that's what the case is about.
Yeah. So what you're calling the tax is the platform fee to
Yes.
be listed on Google Play Store, and Google is using the Google Pay app to process those transactions.
Yes.
And so did Epic also want to institute its own billing aspect as well?
Well, yes, and more. Epic has aspirations to operate an app store, maybe a specialized app store just for games, but some kind of app store in which they would be paid by developers for distributing apps instead of Google.
Okay. So they were really proposing an alternative. So in the sense of so one aspect of it is that Google has to finance the Android system, and it's putting all these apps in place. Very much like Apple, it is charging that 30% revenue from those transactions. The equivalence is
Yes, it's very
almost
much like
like,
Apple.
yeah.
And Epic Games also sued Apple. That's gone down a somewhat different path. It may end up roughly in the same place, it may not. That's been in the news lately. Not the Google case, but the Apple case has been in the news the last couple of weeks. So Epic Games is in the same fight there. They don't want to pay the tax. From my perspective, they are free riders and they're trying to use the antitrust laws to help them free ride.
So when we talk about, the Sherman Act, what are the anti-competitive practices then that Google is indulging in, according to Epic? Uh, is it not letting them collect the app revenue?
Not really. The case is rather misfocused. To make an antitrust case out of this, it was necessary for Epic Games, or maybe I should say their lawyers, to find some market in which you could say competition was being suppressed. So they did. And this is what they call the Android in-app payment processing market. It's a market that has never really existed. There wouldn't be any in-app payment processing were it not for the Google Play Store. And Google is the only one that has processed these payments. It's not really a market at all. It's just part of the Play Store. The case was tried to a jury. The jury said there was such a market, and the jury said that Google was pressing competition in it. And under conventional antitrust principles, if this is a separate and distinct product from the apps and from the services, then requiring the developers to use Google's own particular payment processing system is what's called a tying arrangement. And this sort of tie has the effect of eliminating competition. Maybe it's competition that would never have existed, but has the effect of eliminating competition in the choice of payment processors. And so that looks like an antitrust case. And the jury found an antitrust violation.
Oh.
Now, in fact, this is a little off base because Google actually offered some of the developers the choice to use any payment processor they wanted.
Yeah.
And none of them wanted to use another payment processor. And the reason they didn't is because Google said, well, we'll let you use any payment processor you want as long as you pay us the commission.
Mm-hmm.
And what the developer said is, well, what we want is to not pay the commission.
Yeah.
And Google said, oh, well, that's not being offered.
Yeah.
And so these developers, and I think there were only a couple, said, well, then we don't care if you're the payment processor. And I think that speaks volumes, even though it was a very small experiment. I think that it would be repeated over and over again. I don't think anybody cares. I don't think any user cares. I don't think any developer cares who the processor is. The commission was portrayed as a monopoly price for processing, but it was also portrayed as a tax by Epic Games. They said both things in the same paragraphs, but it can't be both. And they're right when they say it's a tax because a tax is required. The cost of processing is quite small, a few percentage points, no more, certainly no more than 5, probably more like 2 or 3. I don't know. I don't think anybody knows the exact number. I read most of the transcript. I didn't see a good number, but it's small. That 30% or whatever it is, even if it's only 15%, is clearly more than the actual cost of processing. But that was never in dispute. It was always meant to be a lot more than the actual cost of processing because it was financing
The Android.
Android.
Yeah. Okay. So for this case, the judge defined this market as a relevant market. The in-application purchases, was that defined as a relevant market for the case?
Yes, and it was done by a jury. It's a long and complicated and uninteresting story about why the case was tried to a jury. But it is a source of many problems.
Yeah.
So we juries don't explain their decisions; they just make them. So we don't have what we would normally have in an antitrust case, which is a long decision explaining what the facts are as the court understands them, and what the analysis of the application of the law to the facts is. In the Google search decision, which we might talk about later, we have a decision that's 250 pages, give or take. I don't remember the exact number, explaining what the evidence showed. Here we have nothing. And that may change. The Court of Appeals may require the judge to produce such a decision as a basis for the remedy. You can have the jury verdict without any written explanation, but having an injunction without an explanation is a different question.
Yeah.
And the court imposed an injunction, a very broad injunction that has profound impact, and it did so without adequate explanation. And I think the Court of Appeals will have an issue with that.
Yeah. This is a very basic question, but maybe a lot of people who listen to this are not familiar with it. The jury in this case is regular folks. How is the jury selection done
Yes.
for cases like that?
Well, precisely how they do the jury selection in this court, I don't know, but it's done the way it's always done in courts. They have some voter registration list or some other list of citizens in the district. Names are selected more or less randomly. A panel of people are brought into the courtroom. There's a process to see whether any of these people should be disqualified from serving because they have conflicts of interest. They know the lawyers. They know the judge. They work for Google, any of these things. And then they seat a panel of jurors and they try the case, and the jurors go back to the jury room and they render a verdict. They have what's called a special verdict form where the jury is given specific questions to answer. Like one of the questions was whether there is a relevant market for Android in-app payment processing. And did Google monopolize that? And did Google engage in an unlawful restraint of trade to eliminate competition in that market? Those are all questions the jury answered in the affirmative.
Oh, I see. So there was also something called Project Hug. It was alleged that there were other app providers that Google tried to pacify. Is that something that was relevant to this case in particular?
Well, I can't say much about that because in the part of the record I read, which is not the whole record, there was very little about Project Hug. We
Okay.
have no idea whether the jury paid any attention to it at all. Google, I know, said there's nothing to it. I think it is something fairly separate from the basic allegation
Okay.
in the case, but is something that Epic Games put forward as additional evidence of anti-competitive conduct,
Okay.
and the jury may
Okay.
have given it some credence.
But not too much weight. Okay, so we have one outcome in the case of Google versus Epic Games, but a very different outcome in Apple versus Epic Games. Is it the way that Epic Games put forth arguments that kind of appeal to different parts of the jury in terms of is there freedom to access the applications by consumers and
I know less about the Apple case, but I do know a couple of things that are responsive to your question. First, there is a completely different outcome on the federal antitrust claims because Apple won the federal antitrust claims in the Apple case and Google lost the federal antitrust claims in the Google case. But there's also a state antitrust claim in the Apple case, and Google lost that. And based on the latest decision from the district court, it may be that the outcome as a practical matter is the same.
Mhm.
It's not clear for sure, but according to an order that the judge just issued, I think last week, Apple had not complied with the order previously issued under
Yeah.
the state claim, and I don't know exactly what it was supposed to do, but it did apparently it did very little, and the judge was extremely unhappy about that. So there will be further litigation on this. But the judge's attitude is that Apple flagrantly violated the court order. So, in her understanding, Apple was required to substantially revamp
Yeah.
its commission system,
Okay.
and it didn't.
Mhm. All right. And I think it was in the news recently that Epic Games is back on the Apple platform. Google has been frequently under scrutiny by the Department of Justice. What is the current thinking about the role of Chrome in Google's strategy? Is it likely to be asked to divest? These two are lingering issues on hand, the threat of Chrome divestment and what happens to Android. So what is your understanding of both of those?
Well, if Google is not allowed to collect commissions through its App Store, I'm not so sure that it's going to find it makes any sense to continue developing Android. How's it going to make money from that? And the most likely way it can still make money from that is by promoting the use of Google search.
Hmm.
But the government is trying to do everything it can to prevent Google from making any money on search. And the combined result of both of these things, it could be pretty drastic. If the remedies in these two cases, the Google search case and the Epic Games case, go forward as proposed, Google will either be gone in 3 years or it will be in a completely different business because it can't make money in search and it can't make money in app distribution. So it has to find something else to make money in. Now, I'm not at all sure the remedies are going to go forward as proposed. And you brought up in particular the divestiture of Chrome. So that brings us to the Google search case, which is in the DC circuit in the remedy phase right now. Where we are is there's been an evidentiary hearing, which is wrapping up with post-hearing filings by the parties, and then a closing argument that will be held next week.
Okay.
The government, and I'm going to use that term because it's a coalition of the federal government and a large number of states. The government proposed a rather complicated is a crude indication of how complicated it is, 50 pages long. And one of the provisions that takes up very little space is divestiture of Chrome. Part of the reason it takes up so little space is it doesn't define what would be divested. That's to be figured out. And it turns out it's not trivial.
Yeah.
Much of the technology is public domain. The Chromium code
Hmm.
is public domain.
Yeah.
So, but Chrome is a large team of people who maintain the browser, which is not separated from the rest of the Google people. So that presents problems. And certain aspects of Chrome have to be appreciated. And number one, it raises revenue that's approximately zero. I don't think it's exactly zero, but zero is a good number. It was never meant to be a revenue product. Nobody pays a license fee. Nobody pays a usage fee. Chrome exists to promote the use of Google search. And it works because it's a really good browser. Google launched Chrome in 2008.
Hmm.
This is a crucial period of time that the litigation doesn't really get into, and that's a tragedy.
Yeah.
What is happening in this period of time is absolutely crucial, and there's essentially no evidence in this case about it because the government didn't want to talk about it. The government
Yeah.
mostly wanted to talk about the last few years. They focused on contracts in place since 2016. They did talk about some earlier stuff, but they
Hmm.
didn't talk about much earlier stuff. So in the 2004, 2010 period, everything changes. Google goes from being nothing to being
Everything.
80% share
Yeah.
search engine. And they go from not having a browser to having the leading browser.
Yeah.
And this is all from innovation. It was
Yeah.
never alleged that they did anything illegal to obtain a monopoly. And it was never alleged that anything that Google ever did connected to Chrome was unlawful. And a Chrome user is not required to use Google search.
Yeah.
Google could lawfully require it. They could make it impossible for a user to use any other search engine but Google, but they don't. You
Hmm.
can go in your settings
Yeah.
and change it. If you want to use Bing, go ahead. You want to use DuckDuckGo? Fine with them.
Yeah.
It's up to the user.
Yeah.
But very few Chrome users want to switch away from Google search.
Yeah.
One of the very interesting things in the record of this case is that when Google search is the default, the vast majority of users stick with the default.
Yeah.
The government says, well, that's a terrible thing. That means giving Google the default distorts competition.
Yeah.
I'm not convinced.
Yeah.
Giving anybody else the default doesn't have a comparable effect.
Yeah.
And the experiments have been performed. Mozilla performed some, and they were scientifically controlled experiments, in fact. But when anybody else is the default, besides Google search, a lot of people switch to Google search because they trust it.
Yeah.
And in objective tests, it outperforms other search engines.
Yeah.
So you have to say, well, why does the government insist that Google has to be divested? And that's a real head scratcher.
Yeah.
And I think the answer is that they are not trying to promote competition. They are trying to drag Google down.
Yeah. So,
And it will certainly drag Google down to lose Chrome.
yeah. Well, I have a lot of questions before we go further. So it's interesting that you mentioned that when Chrome was developed in 2008, they don't at all go into how it evolved. And so it's the division is trying to just penalize the success of Chrome. Is that correct to say?
Well, basically, I think that's fair. I I think it is completely fair to say that the divestiture of Chrome is a punishment. And that it is a punishment is a very consequential statement. If the district judge decides that it is a punishment, then he is prohibited from ordering the divestiture of Chrome because there cannot be a punishment in this case. This is not a criminal case. We only have punishment in criminal cases. Google wasn't charged with a crime. It wasn't convicted of a crime. It cannot be punished.
Yeah.
The remedy serves a different purpose. The remedy, any remedy in U.S. civil law, is supposed to undo a harm that was done by condemned conduct. And an antitrust remedy in particular
Yeah.
is supposed to undo harm to competition. And surely the government says, well, that's exactly what we're doing.
Yeah.
But there was no harm to competition done by Chrome.
Yeah.
And there is no evidence that Google's monopoly position was not achieved lawfully.
Mm-hmm.
In fact, that's never been alleged. The issue is whether Google would have lost its monopoly position had it not engaged in the condemned conduct. And I believe the law is clear, and logic dictates that the right remedy involves taking away the monopoly if the monopoly would have been lost but for the condemned conduct. It's if and only if.
Yeah.
They would have the monopoly in either event, then it's not a proper remedy to take away the monopoly. It's not a remedy at all. It
Yeah.
doesn't remedy, it punishes, because the remedy undoes the actual harm. Of course, you don't know exactly what the harm is, so you have to
Yeah.
make some guesses. But the remedy undoes the harm to competition caused by the unlawful conduct. So, what was the harm to competition here done by the unlawful conduct? Well, now you have to say, well, what was the unlawful conduct? Well, it didn't have anything to do with Chrome. The unlawful conduct, according to the district court opinion,
Is the
was exclusive dealing. And the court labeled all of the distribution arrangements that Google had entered into with various partners as exclusive deals. So there are basically two kinds of these. There's the arrangements with the mobile device manufacturers and distributors, and there's the arrangements with the browser developers, of which Apple is by far the most important. So everybody knows that Apple has a browser. It's called Safari. What a lot of users don't know is that when you do a search on Safari, it goes through Google search.
search.
And it has all along.
Yeah.
Even before any money changed hands, Google wanted a partnership with a search engine, and it entered into a contract with Google to license Google Search. This was a licensing agreement in which no money changed hands. But Google believed that they had to have a license to do this, and Google was happy to give one.
Yeah.
Well, shortly thereafter, search advertising became a thing, and search advertising has changed everything.
Yeah.
It's a really important thing. You have to remember that in 2000, there was no money in browsers and there was no money in search engines. There was an idea that maybe you could charge people for using these things. It's never worked.
Yeah.
So, what's the business model? Advertising. It's always
Yeah.
advertising. And Google got into it big time and made a lot of money, and they shared it with their partners. So when they renegotiated the initial Apple deal, Apple wants some of the advertising revenue. And Google says, well, that's fair. You should get some. They negotiate how much.
Yeah.
And that's the model for the other arrangements that Google enters into subsequently. And of course, it's a negotiation over the sharing percentage. And the percentage that they hit on depends on a number of things, but of course, one of the things it depends on is what is the partner willing to do for Google to promote the use of Google search?
Mm-hmm.
Because what Google is paying for is customers. That's always what you pay for in a distribution arrangement.
Yeah.
And so they pay more to get more. And the arrangements were not exclusive in the usual sense. And the Apple arrangement is a good illustration. If you're a Safari user and you don't want to use Google search, you don't have to. You can go in there and you can switch the search engine. What Google got was the default status.
Yeah.
If you just open up Safari and do a search, you get Google search. And if you never change, if you never go into your settings and change which search engine it uses, you'll continue to get Google search.
Yeah.
And that's worth something, worth a
Yeah.
lot, in fact. But it's not, in the traditional sense, exclusive. Well, the
Yeah.
judge says, yeah, but it's still exclusive because
Yeah.
there's only one default status in Google. Got it. Okay, I'll buy that. But the somebody else can come in and outbid Google. But they don't. Microsoft has bid against Google, but they don't bid enough. They're not
Yeah.
even in the ball game.
Not in Apple's interest in any.
Yeah, Apple does arithmetic.
Yeah.
Apple says that all these billions they're getting from Google is a really good deal.
Yeah.
And Apple filed a brief in this case saying, we want to continue to do that deal.
Yeah.
They're okay with throwing Google under the bus as long as they get to keep their deal.
Yeah.
Um, so, uh, so the question is, well, what was the effect of the exclusive dealing? And I wrote a brief arguing that there's a series of simple thought experiments that the court should do to see, contrary to its expectations, that the exclusive dealing really didn't have much effect.
Yeah.
And so I would start by saying, imagine a world where there is no search advertising. Would web browsers look any different? And the answer is no. We were in that world at one time, and they didn't look any different. They're still going to have default search engines because the marketing guys and the engineers both like that.
Yeah.
They want the thing to work. They don't want the user to have to configure it to make it work.
Yeah. There has to be one default setting, and then that's a kind of a prepackaged, you
Yes.
get it in. Oh.
And then you can imagine that advertising is invented, and it was.
Yeah.
So what do browser developers now want to do? Well, they want to capture a piece of the pie.
Yeah.
That becomes the business model. It becomes the only business model. Because how else do you finance your browser? Nobody is paying for your browser. So you rent to somebody, Google or somebody else, the thing you have to rent, which is
Yeah.
default status. And everybody does that. And
Yeah.
everybody would have done that in any universe.
Hmm.
Um, and who are they going to rent it to? Who's ever willing to pay the most? And what is search engine is willing to pay the most? The one that gains the most.
Yeah.
And that was Google search. So they do partner up.
Yeah. So,
And so the fact of the partnerships has nothing to do with the exclusivity. And you
yeah.
can even imagine a world in which they're forced to do all this without contracts.
Yeah. Exactly.
How different is it without contracts? Well, certain guarantees can't exist anymore.
Yeah.
But do the partnerships go away? Of course they don't. So, what do you do if you can't have a contract? Well, we've had situations like that in the past. You offer up to pay a bounty. You say, if you steer users to me and I can identify they came from you,
Hmm.
I'll pay you. And I'm convinced that that's what we would have had. And everybody would have offered a bounty, but browser developers would have steered their users to Google because that would generate the most
Most
revenue.
for them. Yeah.
It's all about the money. It's always all about the money.
Yeah.
The mistake that is sometimes made is to think that contracts fundamentally change the way the world works. And they almost never do. They just provide mutual assurances that the world is going to work the way you expect it to work.
Yeah. And also, it's the guiding framework for the two companies to work together.
Well, yes, they can foster greater cooperation, but I'm not sure how much of that happened here. Some, to be sure, uh, but Google is going to have some kind of partnership with everybody else in the Android ecosystem. How could they not?
Yeah.
They are inextricably interdependent.
Yeah.
That's how ecosystems work.
Yeah. Again, going back to divestiture of Chrome, if at all that seems like a kind of a viable remedy, is the government allowed to take the property of Google, and would Google instead demand compensation?
Well, Google would get compensation. If Chrome is divested, it would be sold and Google would keep the money. Yeah, that's how it's always worked in antitrust. And assuming, which
But
is
that
not
would be a
true in this
large
case,
amount.
that it's a proper remedy,
Yeah,
then the court isn't worried about whether the compensation is adequate. The Normally there's a market process to sell these assets, and the market process is supposed to yield a market value, and so that solves the problem of avoiding an unconstitutional taking. If something is sold through a market at the market price, then there is no taking. The sale may be involuntary, but there's still no taking because there is just compensation. And
mhm,
all the Constitution requires is just compensation.
I see. There have been a lot of interviews. Companies have gone and stated their viewpoints on how this competition will play out. There are potential buyers of Chrome if that were to happen. Again, what is the judge trying to do when it invites all the market participants? Are those views incorporated? Because they're all obviously self-serving. So,
Well, the judge is looking for insights, not votes. And I don't know how many insights he's actually getting, but he's being told some possibilities for how Google could be operated.
mhm,
That's interesting.
yeah,
Um, he's being told whether it can exist as a viable business entity. Well, that's
mhm,
very interesting. He's being told whether there would be buyers for Google. That's very interesting. So he's being told some useful things. Um, it is worth noting that the way the government wrote its remedy proposal, it gets to decide who buys Google, excuse me, who buys Chrome.
Chrome, yeah,
Um, Not a market process. So that will raise some issues. And we have no idea on
yeah,
what basis the government will make this decision. Um, it, and I'm not sure that it actually will. It's just reserving the right to make it.
mhm,
Normally, in antitrust divestitures, the government doesn't want to pick the buyer. The government wants the market to pick the buyer because markets work better. The government, there are exceptions, but the government's not completely stupid about whether market processes should be relied upon. The
yeah,
premise of antitrust law is that market processes should be relied on, but once in a while they need a little help. So
mhm,
when you do a divestiture, the way you normally do it is you get the Wall Street types to orchestrate some kind of auction process. You get whatever information needs to be circulated to potential buyers. You and they bid in
yeah,
some fashion, may not be a formal auction.
yeah,
Um, you uh, we in merger cases historically there has been a divestiture remedy when there's been a remedy, and because that's the tried and true remedy. You sell some package of assets, some separate business that would avoid the anti-competitive effect of the merger.
mhm,
And that process is routine. And
yeah,
that's in the government's mind when it says divest Chrome.
mhm,
Even though it's not a separate business, that creates complications. But merger divestitures frequently don't divest separate businesses.
yeah.
So this can be done. Just a question of how hard it is. Google has claimed it's very hard in this case,
Mhm.
and that might be so.
But this is a very unlikely outcome. Is that right? I mean,
Well,
uh,
I think it's rather unlikely, and I was chatting with a reporter um, a few weeks ago, and the reporter said every antitrust lawyer she talked to said it wasn't going to happen.
Yeah.
She didn't name any names. She didn't tell me how many antitrust lawyers she talked to. She said every one of them said it isn't going to happen.
Yeah.
So,
Because it seems too harsh. And given that
it
Google has been innovating and that is the preferred browser on
seems
all
like a
accounts. Yeah.
punishment, and a
Yeah.
punishment is not what this is about.
Yeah. So, but nevertheless, I think Google is under a lot of scrutiny again. Also in
Absolutely.
the advertising case.
There's a lot of technical detail in that case I simply don't know. Maybe they
Yeah.
did something wrong. I don't know.
When the Google management talks about the likely impacts of antitrust, they refer to, of course, the idea of consumer welfare, how that would suffer immensely with these kind of decisions. Are those arguments being presented? Very important development that is happening is the rapid pace of innovation on the AI front. And Google already being a leader in the browser space is also incorporating competencies in that as well. And it points to the role of national security. And so, how are those arguments going to be taken by the judge in this case?
Well, I don't know. These are hard problems. I
Yeah,
can tell you in the Epic Games case, the judge had a very simple approach. He, even though, and I will say from the start,
yeah,
wrong-headed, simple-minded approach. Even though the case was about this incredibly narrow and unimportant market for Android in-app payment processing, he believed the jury verdict was a sufficient basis to terminate Google's perfectly lawful monopoly in Android distribution. Um, there, there was no allegation that Google unlawfully acquired or unlawfully maintained such a monopoly. Yet, the judge asserted that he was, maybe required is slightly too strong a word, but it's getting there, required to do something about this monopoly. And that's just wrong. It's a
yeah,
lawful monopoly. You don't do anything about it. The judge in the search case seems to have a similar attitude. And it's been clear all the way through the trial. Now, in some ways, it is more justified in the search case
mhm,
because although the monopoly was not unlawfully acquired, the allegation is that it was unlawfully maintained, and the court sustained that allegation.
yeah,
So the judges found the monopoly was unlawfully maintained. And it was clear during the course of the trial that the court wrongly, completely wrongly believed that Google could not have held its monopoly all these years without doing something wrong. I just could not understand this attitude. Why do you believe that the most innovative guy on the block loses his monopoly? How? How does it happen? Well, eventually somebody's got something different and better.
better, yeah,
Eventually. But it wouldn't have happened by now because
mhm,
that thing hasn't come along yet. So he, and the government obviously realized this. He was sympathetic to a very severe remedy. Now, maybe he's lost some of his sympathy. Maybe he's been brought down to earth more by these remedy proceedings and the
mhm,
briefs that have been filed, including one by me
yeah,
saying, you can't do this. Uh, and I think he's also going to realize, which the judge in the Epic Games case clearly didn't, that a lot of bad things can happen.
yeah,
The judge in the Epic Game case gave no thought to the fact that Android could simply wither and die as a
yeah,
result of his order. Where's the money going to come from? And if there's no money, how does it go on? Well, in the search case, it was almost laughable to hear the testimony of the government's expert explaining how the remedy was going to shift some usage away from Google. Well, the remedy is draconian. Google has to give away everything it's built. So every one of its rivals can clone Google search, and they don't even have to. The remedy requires something called syndication. What that means is that I can put out Greg's search engine, which is just Google
Yeah.
under the hood. Google will require to do my searches for me. Now, if they do syndication, they get to keep the money. But um, these are extraordinary remedies. Google has to give everything away. They don't get to split the costs. They have to bear all the costs, but split all the benefits. So, are they going to invest under those circumstances? I don't think so.
Yeah.
I think they're going to shut it down. They got to find a way to monetize. They
Yeah.
can't compete on the basis of quality because whatever they produce, they have to give away to all of their rivals for nothing.
Mm.
And they can't compete on the basis of price because price competition isn't about charging users less. No, they already charge zero. There's no
Yeah.
less.
Correct.
It's about paying for distribution. And they're not allowed to pay. They are literally barred from competing for distribution. Now the government says, well, they can compete in some other ways. Money talks. If you're not talking money, you're not talking.
Yeah.
Oh, oh,
So they want to commoditize the
they
browser
do
market.
want to commoditize search, but that's they won't say that,
Yeah.
and and they have high hopes that that's not what will happen. That this cloning is just a transitional phase. That competition will shoot off in unpredictable directions that where competition always shoots off. And
Yeah.
maybe that's right. But what we know is Google won't be there because
Yeah.
Google's not allowed to play.
So it's Google innovating is okay. Google monetizing is not okay. That's kind of the message.
Well, not only can they not monetize, but
Yeah.
they have to give away whatever they create.
Yeah. And that seems very,
So everybody else gets to monetize their investments.
yeah.
Well, that's not sustainable. And of course, it isn't meant to be sustained. But the government wants it to last for 10 years. Well, 10 years is forever in
Yeah.
this business.
In this world. Yeah.
So you never know. Some things that you think aren't going to last long do, and some things you think are going to be forever go away in a year.
Yeah.
It's very unpredictable. But most people think that AI is going to change things a
Very.
lot in the next 5 years. So what's it going to look like? I don't know. Um, but Google's trying to get ahead of the curve by incorporating AI as fast as they can. And so are other people. Giving them access to whatever Google has created will help them,
Yeah.
but it may also steer them in completely different directions than they otherwise would have gone. This is something people have to stop and think about. Right now, you have certain options, but this remedy gives you another option you never had before, which could be your best option. Just steal what Google's got and try to do something with
Run
that.
with it. Yeah.
Don't innovate. Why
Yeah.
innovate when you got all this good stuff from Google?
Yeah.
So it distorts choice profoundly.
Yeah.
So it is completely unpredictable what's going to happen in this space if the government remedy is put in place. And the government, I think, will concede that. But they say, oh, but whatever happens will be the product of competition. And what I say is, but you've punished Google for winning the competition.
Yeah.
How does that promote competition?
So the FTC has filed an amicus brief. And is this the first time that it has done so with regards to privacy of data and how Google should share users' data with its competitors? What is all that about?
Well, I don't know what's going on behind the scenes. I didn't even when I worked in the most of the time, even when I worked in the Justice Department.
Yeah.
But I think partly it's federal government is a completely different place now. Whereas in the past, the FTC stayed in its lane and the Department of Justice stayed in its lane. Now there's only one lane. It's the Trump lane. So the FTC is supporting what it understands to be the Trump policies. That's what I think is going on here. The chairman of the Federal Trade Commission makes all the right pro-Trump noises all the time. I don't think anybody lasts very long in this administration if they don't do that.
Oh,
President has fired 2 FTC commissioners. That's in litigation because Supreme Court has previously said the president can't fire FTC commissioners. So we'll see how that comes out. But I think what the FTC has done is unique and probably a result of the way the federal government is so much more unitary than it has ever been before. There's no longer any such a thing as an independent regulatory agency.
I see. Um, well, so on the face of it, it's kind of a toss up, but as you've said, the economics that Google has innovated and it has been the leader, and on that account, it should not be punished for sure.
It shouldn't be punished without any
Irrespective of,
consideration of
yeah,
anything
yeah,
because that's never been on the
yeah,
table. The question is what makes sense to undo the harm that was done to competition? And
yeah,
the answer is that you don't allow Google to constrain the market with particular contractual terms that would make the contracts into exclusive deals. You guarantee
hmm,
that rivals have appropriate opportunities that are not contracted away by Google's partners. And so you write a list of prohibitions for what cannot be in Google's contracts. Say, well, you can't pay money.
yeah,
Oh, that's like saying you can't compete at all.
yeah,
You compete by paying money. It's ridiculous. Their government has always made a big deal out of the fact that all this money changes hands. But how could it be any other way?
yeah. So the remedies, instead of going for the really bold ones, divestiture, cannot the government simply, as you said, lay out, well, this is allowed and this is not allowed in the contracting process, or instead of these knee-jerk kind of remedies, have more incremental guidance,
More than guidance. You want something very clear and very
enforceable.
specific.
Yeah, I
And
mean, but
and
that,
that is
yeah,
what the court should do. And
yeah,
maybe it's what it will do.
yeah. On the other side, in the court, they've introduced all these email discussions that happen between Google officials and how they were deleted. So, what I'm trying to say is there a case for people in business to have some kind of education about the antitrust laws so that when they communicate, they're aware? Or is this something that is regular communication that they did as part of increasing their business, which then, of course, was brought into the case as evidence of anti competitive behavior? What is your thought on that? I think it's just,
Well, Google was perfectly allowed to have policies that avoided creating documents. That's legal.
yeah,
Once they were under investigation, the rules changed. And that is where they got into trouble. I won't get into details. I can't even remember all the details, but
mhm,
what they did was akin to document destruction and really close enough that the judge was upset about it. And
yeah,
more than one judge has been upset about it because,
mm,
it affects multiple cases. And I haven't paid very much attention to it. It's not of much interest to me as an
yeah,
economist or as an antitrust scholar.
mhm,
The what I found consistently in these cases when I was doing them over a career is that I just couldn't get excited about these emails.
yeah,
They they weren't these explosive things
mm,
that the lawyers made them out to be.
Yeah.
Mostly they were impenetrable. They were very insider talk.
Yeah, exactly. And how to improve their
And they
business.
were little snippets from conversations
Hmm.
and very hard to get anything out of them. And I paid no attention to them. The last case where I was involved in looking at documents,
Hmm.
I I was I wasn't actually required to do this. I just was volunteering. I read only two types of documents. I read spreadsheets and PowerPoints.
Yeah,
Only two. It wasn't in one of those two formats.
you would not.
I didn't look at it.
Yeah,
I found the PowerPoints great because these were all efforts to communicate with outsiders.
yeah,
And so they were telling a story. And they needed to explain the business to somebody who didn't already know about it.
yeah,
When two experts talk to each other, they speak in a shorthand and in a code, and I can't follow it.
correct. There's no context of why things are being said. Okay, so the real decision comes out in August.
Like,
Yeah, and well,
in the Epic Games case, the Court of Appeals could decide any moment,
oh, is that
literally any
yeah,
moment.
yeah,
The court's not quite open yet in California,
yeah,
but the court took the appeal on an expedited basis. The, it was the court's decision to expedite, um, and that means that the decision almost surely will come out more quickly than a normal decision.
yeah,
But I don't think it will be an explosive decision. I don't think it's going to
yeah,
either. I don't think it's going to either affirm or reverse. I think it's going to make the judge do it over to some extent and write a long opinion with findings and explanations, which will then be appealed.
yeah. The appeals process, that means a stay. Yeah,
Well, there's already a stay in
yeah,
place,
yeah.
and I think that will stay in place.
Mm-hmm.
Uh, just a guess, of course.
Yeah.
I'm hopeful that the Court of Appeals will just throw it all out, but I think that's really unlikely.
Mm-hmm.
I listen. Anybody who wants to watch the argument in the case can do so on YouTube. The Ninth Circuit is the only circuit that puts up all of its arguments on YouTube,
Oh, is that so?
and um, and it's a long one,
Yeah.
uh, and you might not get a lot out of it if you've not been following the case. But
Right.
what you get out of them is some sense of where the judges are leaning,
Yeah.
and you don't get the sense that the judges were outraged at this decision and are
Mm-hmm.
looking to throw it out. And you rarely get that, particularly in jury cases.
Yeah.
Courts of appeals are looking for ways to uphold what's been done rather than go back and do it over. That's very costly.
Mm-hmm.
And of course, if they do it over, it won't be in front of a jury. But I don't think that there's going to be a new trial.
And so the likely outcome is,
Well, I think the judge is going to have to write a new opinion, and I think he may be cautioned to be more careful in his choice of remedy, and that the remedy needs to be proportionate to the violation found. And when the violation is in the Android in app processing market, that is not a justification for completely redoing
the Google
the
thing.
entire app distribution business.
Mm-hmm.
Um, I that should not be sustainable on appeal. It's completely disproportionate relief,
Yeah.
and I think it's completely unsupportable. Should the case go to the Supreme Court, there's no way the Supreme Court would sustain that. But there's only a tiny probability this case will go to the Supreme Court.
Yeah. So all of these cases can ultimately go to the Supreme Court.
Absolutely.
Yeah. So it's but
But the court has nothing on its docket but Trump cases now, so I had no room for antitrust.
right.
Um, Historically, the court did less than one. Well, I shouldn't say historically. Of the last 20 years, the court has done less than one antitrust case a year, maybe one every 3 years. Um, so it's always very unlikely
Yeah.
that they'll take a case, and when they do, never quite sure why they picked that one.
Hmm.
So um, I had thought they would take one of these NCAA cases, and they finally did a few years ago,
Yeah.
and they upheld the decision that the NCAA violated the Sherman Act. I wasn't at all sure they were going to do that.
Yeah.
Um, but now they're done with the NCAA for a generation. So um, I think maybe we're due for a tech case.
Yeah.
I'm not sure what you count, but arguably there's never been a tech antitrust case in the Supreme Court. Um, so one of the Google cases could be that case.
Yeah.
Um, but Microsoft tried to get the Supreme Court to take its case, and the Supreme Court wasn't interested. They're usually not interested.
Yeah. Okay. Well, it's been fascinating to know all the details about the cases with Google and to gather all your insights. Is there anything else that you want to say as your last assessment over all the things that we've talked about?
Well, one thing that I'm gathering from these cases, and I really hope the Ninth Circuit addresses this in the Epic Games case, but I doubt that it will, is that there's a myopia problem. And it's particularly acute in the Epic Games case. Um, there's a big picture in these cases, and it's being missed.
Yeah.
And there's actually an idea in antitrust that you're required to miss it, that you cannot look outside the relevant market and look at the bigger picture. And
Yeah.
I think that that is a horribly wrong-headed idea that
Mhm.
some court needs to explicitly reject.
Okay.
When the issue has been discussed by the Ninth Circuit not that long ago, but not decided. And because it wasn't decided, the judge in the Epic Games case, the district judge, said, well, I don't know what to say. Epic Games says I should look outside the market. Google says I have to. The Ninth Circuit says there are cases going both ways. I don't know what to do. Well, the Ninth Circuit should tell him what to do.
Okay, yeah, that makes sense. All right, on that note, I'm going to thank you very much again for being a return guest on my show, and I really appreciate it.
Well,
And
you're
until next time, we will look forward to your views on the show. Thank
goodbye.
you very much. All right, bye bye.